Listen because test will be given after the discussion. Okay? So keep quiet because I am recording my discussion and going to upload this one. Maybe after my discussion. Okay? So I will not stand because there's a logo here about this school which I do not want others can see. Maybe a treason on maybe I may be sued for usurping a faculty of other school which I'm not prepared that I am supposed to record my discussion today. Okay? So I will not stand otherwise they can see the logo. Now, last time we talked about the jurisdiction, okay? And lastly, we talked about the exemptions, right? So we'll start now our discussion on the exempt. Who are those exempt? Okay, first of all, we talked about the act of the state. Okay, what do you mean by act of the state? These are actions which are offered by a state. The reason is that all states are equal. Okay, so no state is above the other. That is why a state cannot be sued by another state. Okay, so all sovereign are equal. Okay, what do you mean by doctrine of state immunity? It simply means that the state enjoys immunity from the exercise of jurisdiction. Okay, so the state cannot be sued or it is immune from suit from another state. What are the waivers of a state? When the state gives its consent, like for example, when a state enters into a contract. Why? Because it would be unfair for another party if they can be sued and yet the party suing them cannot be sued. Okay? So to give an equal footing, the state who gives consent or enters into a contract can also be sued. Now, the immunity of the United Nations, its organs, especially specialized agencies, other international organizations. Okay, why are they exempt? Because in our discussion, international organizations are also subjects of international law. Okay, so they're also given an exemption. Another is diplomatic immunity. What are those diplomatic immune? What are those? Why are they immune from suit? Because they represent the state. Okay? So in order for them to act freely and they will not be hampered by their activities by answering different suits, they are immune from suit. And who is the right person or what agency that may be questioned their activity? For example, if they want to be sued, it is the Department of Foreign Affairs. Okay? And the determination made by the executive department is a political question whether to give such immunity or not. Okay? Another exemption from jurisdiction is foreign merchant vessel exercising right of innocent passage or arrival under stress. What do you mean by innocent passage? Example, there is a typhoon or the state, if their destination is this state, but the only way is to pass directly. Otherwise, they will suffer. They cannot reach without suffering from lack of fuel. Okay, so they may enter a state provided that they will not cause any harm. We call it as innocent passage or under stress, arrival under stress. What do you mean arrival under stress? For example, there is a typhoon, okay, and the only way for them to to be alive and to secure the cargo is to go to the state in which the vessel has no right of entry, okay, meaning it is not a flag state or not a vessel of certain state. Okay, what do you mean by flag state? The vessel is traveling under a flag of a certain state, okay, or registered in a certain country. If it is not registered in that country or state, it has no right to enter. Okay, the only way is exemption is when it enters under stress. Okay, the meaning of under stress is, let us say there is a typhoon, okay, or any mechanical problem in which without going or seeking help from a neighboring country, they may suffer loss of the cargo or even loss of the lives. Okay, that's one exemption. Another is foreign armies passing through a station in a territory with the permission of the state. Okay, for example, two states enters into a treaty that they're going to send military to that state. Okay? Before arriving the state, let us say if the territory is bounded by other states, meaning you cannot go directly where you want to go unless you pass by other territories, right? So, what is the do they have rights or does the country in which they pass through has jurisdiction over them or should they shoot them? No, because under the law, they are exempt. Foreign armies passing through or stationed in the territory with permission of the state. Okay? Generally, as we explained in our first meeting, if the state the state territory is within and above and any persons or object coming from other country that pass through it, the state has the right to defend. One of that right is to shut down any airplane that passes by our territory or a vessel that enters within the 12 nautical miles of the territory counting from the low water mark starting on the baseline. State has the right to stop it. Why? Because that is an intrusion to our sovereignty or territory. Okay? Now, that is an exemption. Okay, foreign armies passing through it. Okay, take note the 12 nautical miles that I gave you is an exclusive right, meaning the owner state has the right to use it exclusively, excluding other countries. If other countries will get in, we have the right, by all means, to defend the territory. Okay? Now, another warship and other public vessels of another state operated for non-commercial purposes. Okay? So, warship is owned by the state of another. If it enters to another territory, other territory like Philippines, no jurisdiction over it. Reason again, each state are equal. Okay? So it is the warship is an extension of the territory of another. It is a floating territory of another state. A local jurisdiction when on shore, except when what is the exemption? Their crew members are immune from local jurisdiction when on shore duty, but immunity will not apply if the crew members violate local laws while furlough or off duty. Our example, who is our example? Okay, the latest case. Okay, um, the the victim was a transgender, and they were, I think, raped or maltreated by servicemen, okay, from the United States. So they can be held criminally liable, although in general we do not have jurisdiction over them. But when they are off for law or off duty and they committed a crime, okay, in the locality, then they are not exempt from Philippine jurisdiction. Okay. Now, what are the propositions underlying the grant of international immunities to international organizations. International institutions should have a status which protect them against control or interference. What does that mean? If they are in our territory or the territory of the receiving state has the right to protect at all costs to them. Why? Because that is our obligation under the international law. Because if something happens to them, because we lack protection over them, then the state will be held liable in the United Nations. Okay? There was a case, an embassy in, I think, Middle East, okay, there were so many protesters to the extent that I think one of the ambassadors was hurt. Okay? The ambassador of the state um, seek help from the United Nations, file a case. So the receiving state is liable for not protecting the heads of state or persons supposedly immune from the suit. Okay? So no country should derive any national financial advantage by levying fiscal charges on common international funds. Okay? Now, we go to the methods, okay, of granting privileges and immunities to personnel of international organizations. Okay, how are we going to grant them the exemptions? Why should we grant them exemptions? What's the reason again? Because they represent the state, okay, and its states are equal. Okay, no state is above the other state. Okay. Now, what are those three methods of granting privileges and immunities to the personnel? One is, okay, by simple convention stipulation, which is by some states will invite other state for a convention. Okay. What else? Internal legislation. The country may make a law that will perhaps solve a problem with other state. Okay, to grant privileges and immunities. And then what else? By combination of the first and the two. Now, how about those private acts? Let's say um, they are immune, right? But what if they committed the private acts? Huh? What is the stand? The General Convention on the Privileges and Immunities of the United Nations has been interpreted to mean that officials of the specified categories are denied immunity from local jurisdiction for acts of their private life. Okay? So, what is the criteria to determine whether the state has jurisdiction over their acts? If it is in accordance with their functions and duties. If it is outside, then they are not immune. Example, their job is to give information as regards the commerce of that country. And yet, instead of giving a report on commerce, he gives a report on private affairs, like going into karaoke bar, and he commits a crime. Okay, is he still immune from suit? He is not. Okay, that privilege or immunities, okay, does not grant to personal or private life. Okay. Now, what are the modes of resolving conflict of jurisdiction? Would there be conflict of jurisdiction, or when would that arise? Kosaman, when is there a conflict of jurisdiction? Okay. Is it possible that there will be conflict of jurisdiction? Huh? Yes. Okay. What are the examples? Can you give me an example? When? Huh? Louder. Yeah, West Philippine Sea. Well, that is on territory, right? What if, how about the person? The acts of a person where two countries acquire jurisdiction. Okay? That's why we have a conflict of laws or private international law, wherein a law of the country in which they are citizen, the laws are conflicting. Okay, for example, the country allows marriage of, let us say, below 18. But in our country, we do not allow marriage below 18. Okay, so there is a conflict. Let us say both countries, citizens of those countries are getting married. So there will be conflict. Okay, now, as to jurisdiction, what are the modes? One is balancing test. The state shall assume jurisdiction when acts intended if effects is sufficiently large and strong. Okay? Normally, the state, in the absence of a clear provisions of the law, will always make an initial step to acquire jurisdiction. Okay? Was the purpose to determine whether the case, where there is sufficient large or strong, okay, case. Another is international committee. What do you mean by international committee? Okay, friendship, right? The meaning of committee is friendship. What does that mean? Even when the state has basis for exercising jurisdiction, it will refrain from doing so if it exercises will be unreasonable. Okay? So that is why in dealing with state, you always exercise in good faith. Okay? If you think that um, would be unreasonable, then even if you have jurisdiction, you may not. You may what's the other term of not deciding it or not acquiring jurisdiction? You may inhibit or not to file, not to acquire the jurisdiction over the case. That's the meaning of international committee friendly. Even if you have, but it's unreasonable, no need. Okay? Don't have to insist. Now, another is forum non-convenience. What does that mean? Application is discretionary, the courts weighing private interest factors and public interest factors. Okay? So, the state will weigh which is better, the private interest or public interest. So, in forum non-convenience, the state may give or relinquish its right in favor of another country if it's favorable or convenient to other country resolving the issue. Okay? If it is not convenient to resolve here, then the state can relinquish its jurisdiction in favor of another state. That is the meaning of forum non-convenience. In what way? For example, the witnesses are not available in our country. Okay, although the crime is committed here, but the criminals are already outside the country. Okay, it may be tried the other country which the persons, the accused are residing may be of convenience. Okay, meaning they are the court. It is the court that acquires convenient because it is not convenient for Philippines deciding the case where accused are outside. Okay? That is the meaning of forum non-convenience. Now, we go to the principles of treaty. Okay? A treaty is, in ordinary parlance, we call it as contract, okay, for private persons or corporations. But since we are dealing now with states, we call it as treaty. Of course, treaty is higher than ordinary contract. Why? Because if you do not follow the tenor of of the treaty, there will be war. Okay? So in contract, if you will not obey the tenor or the agreement in the contract, then the other party may sue you for damages. But here, it's different. Although UN may punish a state for not abiding with the treaty stipulations, sometimes it may even result to a declaration of war. Now, what is a treaty? It is an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments. Okay? Where can you find that? That is a definition under the Vienna Convention on Laws of Treaty. That's the meaning of VCLT in Article 2. Okay? Now, should it be in writing? Yes. Why? Why should it be in writing? Because if it is unwritten, the unwritten shall not affect its legal force. So, just like a contract, although contract is both written or unwritten, okay? Is there a contract that is unwritten? Yes, there's a contract. Because a contract is what? An agreement. Okay? A contract is an agreement, is the meeting of the minds. Okay, it doesn't mean that two heads bump each other. That's meeting of the minds. No. Meeting of the minds means that parties agree to the tenor, to the terms. For example, when you ride a jeepney, okay, the contract there is that upon stepping on the stepping board, the driver will bring you safe and sound to your destination, provided that you have to pay the exact fare. That's the contract. Okay? So if the jeepney driver did not bring you safe and sound because you meet accident along the way, then you have the right not to pay because there was a breach of contract. Okay? So contract, similar to treaty, is the meeting of the mind, but this one is always in writing. A contract may not be in writing. Okay? But there are contracts which requires a formality, such that if it's only unwritten, it has no binding effect. For example, a contract of loan where the amount involved is more than 500 pesos. If it's less than, if it is not in writing, it has no effect. Or a sale of real properties like house and lot. If it's just verbal, it has no effect. Although binding by parties, it has no effect. Okay? So there are contracts which sometimes would require a written instrument for its validity. Do you follow what I'm saying? Now, in treaty, it's always written. Why? Because if it's written, there's no force. Okay, and you know these are agreement between heads of state, and every 6 years sometimes they will be replaced. So that the contract will stand for a lifetime, it must be in writing. Now, under the Philippine law, who has the power to make treaty? Huh? President. What's the answer? Okay. So take note of it. It's not Congress, because sometimes when you will be in a hurry, you will answer the two-third votes of Congress wrong. It is Senate. Okay? It is entered by the President. Okay? And approved or concurred. The word there is concurred by the Senate. The required vote is two-third. Okay? Two-third. Now, what if it is not concurred by the Senate? What is the effect? Huh? Would it be binding? Still. What's your answer? No? Any other answer? Yes? What's your answer? Oh. but you're only guessing because you think, it's not definite, you're not sure of your answer. I want a sure answer. What's the answer? Anybody? What will happen if, although signed by the president and yet was not concurred by the Senate? Huh? Hmm? Invalid? Huh? Are you sure? And did you find there that if it is not concurred by the Senate, it's invalid? What will happen? What do you call it now? How do we treat that um, piece of paper entered by the president and not concurred by Senate? How do we treat it? That will become an executive agreement. Okay? And what is an executive agreement? An international agreement embodying adjustment details, carrying a well-established national policies and traditions, or those involving arrangements of a more or less temporary in nature. Okay? It will be just a temporary nature. But, is it binding? Okay? Yes, it's binding. It is called still an international agreement. Okay? Now, distinguish treaty now from executive agreement. By that, of course, you know now the definition or the distinction between treaty, which requires again two-thirds votes of the Senate. How about executive agreement? Okay, so the last there in the distinction. In the perspective of Philippine law, a treaty is concluded by the President with the advice and consent of the Senate. The requirement is two-thirds. No treaty or international agreement shall be valid and effective unless concurred by at least two-thirds of all the members of the Senate. On the other hand, an executive agreement concluded by the President based on authority granted by Congress are based on inherent authority granted by the Constitution. Still, the President can enter into an executive agreement such that if it is not concurred by the Senate, two-thirds vote of the Senate, the treaty will become an international agreement, an executive agreement rather. Okay? So, in international level, is there an distinction as to its effectivity? There is no distinction. Okay? There is no distinction in their binding effect upon states as long as the negotiating functionaries have remained within their powers. Okay? So, as to international level, executive agreements and treaty are just the same. Now, we go to the elements of treaty. There are, how many elements? 5. One is the parties. Okay, who enters into a treaty? Who enters into a treaty? It is the heads of state, right? Or in the absence of the heads of the state, the alter ego. Who is the alter ego of the heads of the state? Department heads. But in this case, the one that deals with states is the Department of Foreign Affairs. So it's the Secretary of Foreign Affairs. What else? Made through their authorized organs or representative. It is the one I'm talking about. Okay, may be exercised by the alter ego of the president. And the third rather is without attendance of duress. What do you mean by duress? You are forced to sign. Fraud. Okay, all the while you were thinking that it is genuine, but after all, it's not. Okay, you signed a treaty because of fraud. Okay, or mistake, thinking all the while that this is it, but it's the other way around. Or other vices of consent. What do you mean vices of consent? Meaning you signed an agreement Okay? Because, but in reality, you don't want to. Or if the intention is this, you will not really sign, but because of vices, meaning a defect, like you signed the contract while you were drunk. Okay? Okay? So there is no contract at all or treaty at all. And then fourth, it has lawful subject matter. What do you mean by lawful subject matter? Meaning the contract is not illegal. Example, a contract of entering into commerce, okay, on legal items only. But if the importation, for example, is illegal, like importation of illegal drugs, the contract is treaty is invalid because the subject matter is unlawful. And then the fifth is it must be ratified in accordance with the respective constitutional process. In our case, it will be ratified by the who ratifies. Who ratifies the treaty. Huh? Senate only concurs. It's the president. Okay. Now, what are the steps in treaty making? What are the steps? One is negotiation. Second, signature. Third, ratification. Fourth, exchange of instruments of ratification. Last is registration with the United Nations. What is the effect if it is not registered in United Nations? Would the treaty still be binding between countries? Huh? Let us say it's not yet registered and there's a violation now. Along the way, you signed already, but on the day when it is signed, a party to the treaty violates the tenor or stipulation of a treaty. Can you sue them in United Nations? No, of course not. Okay, but the treaty would you insist that the treaty is binding already? Huh? Would you insist that the treaty is already binding? Yes or no? Oh, no, why?
Because it's not wala ka na register sa UNHC. It doesn't
Ah,
take for
any other answer? Would it be binding already? So the answer is the treaty is binding between parties only. Okay? How are you going to resolve? Let's say there are conflict between two of you because one did not follow the stipulations. Can you go to UN? And no, of course not because it's not registered in UN. But you can ask if the other party would agree, a third party, meaning ask a certain state which is not a party to the treaty to intervene or uh, mediate. Okay? Mediation or what's the other term for mediation? Conciliation. Okay? Or arbitration. In mediation, parties may not stipulate conclusion or no penalty at all. But in arbitration, there will be penalty or sanction. Okay? Can other party denies the penalty imposed by the arbitrator state? Okay? No more because he waives his right. Okay? By the time the other party agrees that there will be an arbitrator, then if the arbitrators, if the third state found promulgate a penalty to other state, the penalty cannot be questioned anymore because he is now stopped. Okay? All the while you think that he has authority to promulgate penalty, and yet when he promulgates the penalty, you deny his authority. You are now stopped. Now, may a treaty violate international law?
Yes.
Is there a possibility that a state violates international law?
Yes.
Okay, yes. A treaty may violate international law when, at the time of its conclusion, it conflicts with the peremptory norm of general international law or the use of organs. Okay? So, a treaty must know what are those international principles. Otherwise, the treaty stipulation will be violative of international law. What is ratification? It is a formal act by which the state confirms and accepts the provisions of a treaty concluded by its representative. It is generally held by an executive act. Okay? Why executive department? Because it is a political in nature. Now, what is accession? What is accession?
Status by which a state expresses its consent to be bound by an already existing treaty.
Okay. So, you express yourself to be bound by the treaty. If I am a third state and there are treaties entered into by other states, and if I like it, I may accede. That is called accession. You claim to be bound by the treaty. You acceded to the treaty. Are you now a party to the treaty? Are you now a party? Do you understand what I'm talking about? Okay, you are now a party to the treaty. Okay, the state expresses its consent to be bound by the treaty, by the existing treaty. Okay, so you enter into the scene of the treaty between other states. What is reservation? Purports to exclude or to modify a legal effect of a certain provision. You like a treaty. I like this. But you have a reservation. Except this portion, I do not like this. That is called reservation. What is the principle of pacta sunt servanda? A fact must be respected. What does that mean? At all costs, a party to the treaty must adhere. Okay? Must be a servant to the treaty. Meaning they have to follow what is in the treaty. That is the meaning of pacta sunt servanda. A pact must be respected. They must perform them in good faith. Okay, let us say you enter into a contract and later on you withdraw at your own advantage, at the disadvantage of another state. You are liable for what? Principle of pacta sunt servanda. You are in bad faith. Okay? You are insidious. Do not apply that in treaty. Okay? You're wise. Okay? Do not apply that. Why is it so? What's the intention of having this law? For us to have a peaceful world. If you apply those principles of not following the Pacta Sunt Servanda, there will be a chaotic world. We do not want that. Now, what is the general rule on interpretation of treaties? Always in good faith. And then interpret it in the ordinary language. Let us say the one who was writing the treaty, preparing it, because there are two languages that a treaty may be, or even a judgment in the Hague, there must be it must be written in the language, English language and French. Let us say there are conflict because not all those in heads of state are well versed in English, right?
Yes.
Yes, even Japanese cannot even speak. The Japanese prime minister cannot even speak English. They have translators. Supposing there is a mistake in the interpretation or in the writing, that is not what actually they want to enter into, but because of the barrier in language, there was now a confusion. How are you going to interpret it? It must be interpreted in the ordinary meaning. Okay? And what's the next? Aside from ordinary meaning of the language,
In the light of its object and purpose.
in the light of its object and purpose. In the light of its object and purpose. Now, when may a treaty invoke a fact that its consent to be bound by the treaty has been expressed in violation of the provision of international law? Oh, it's not important. We go to other one. What are the grounds for the validation of the treaty's consent to be bound by a treaty? Error, fraud, corruption of representative of a state. Okay? What are forms of corruption? Giving money or giving woman. Okay? Sometimes, in order for you to sign, they give a beautiful woman. Okay? They let you accompany a beautiful woman. Okay? So instead of signing a treaty that will benefit your country, you sign a treaty that benefits another country. Would that be a treason? Would that be a crime of treason? Huh? Is it treason? It's not treason because treason is only committed during wartime. Okay. Huh? Um, Now, corruption. There are many forms of corruption, but the meaning of corruption under the Graft and Corrupt Practices Act refers to a character of a person. It's not only giving money or receiving money. It's all about the character of a person. What others would perceive you as who you are. If they perceive you as ill repute, then you are a corrupt. Coercion of a representative of the state. Okay? You were forced to sign. That's coercion. And then conflict of peremptory norm. Okay? And conflict of provisions of internal laws. What is rebus sic stantibus? Rebus sic stantibus?
The principle and customary international law and Treatise is written has been a fundamental change that given a party that has been able to
So it simply means if there's a fundamental change of the treaty of the circumstances,
any
okay,
party
the other party may withdraw. For example, there's a treaty now binding, and yet because of circumstances, something happened, the other party can actually withdraw. Okay, that's the principle of rebus sic stantibus. Huh? Yes, but well, the pacta sunt servanda still applies, but in this case, because of a certain event which would affect the consent now of giving treaty, you can actually withdraw. For example, we enter into commerce with other country that we're going to supply them with let us say sugar cane, 50 tons a year. Let us say there's a typhoon, we cannot supply it a year. So that is a reason for other country to what? To withdraw. That is called pacta rebus sic stantibus. A fundamental change of the circumstances that other country may withdraw. Now, we go to doctrine of state responsibility. What do you mean by that? Is state responsible for an internationally wrongful act?
Yes.
Okay, the answer is yes. Every internationally wrongful act of a state entails an international responsibility of that state. So if a state committed a violation, okay, it may be liable to other state. What are the elements of internationally wrongful acts of state? There is an international wrongful act of state when conduct consisting of an act or omission. Okay? What do you mean by act? It acted. Okay? It performs something that is act. Omission. It did not perform and yet still there is injury caused. That is omission. Omit. You omit an act an act which is supposed to be done. Okay? Now, what is attribution? Or what's the other term of
Imputability.
imputability? Is a legal construct whereby an internationally unlawful conduct of state organ acting in its capacity is regarded as a conduct of a state itself. Okay? Making the state responsible for it as an international wrongful act. Okay? So this may be committed by an individual or a group. May be committed by an individual and yet the responsibility is attributed to the state.
Illegal sa state, sir.
Okay? Huh?
Illegal sa state, pero nakaviolate sa internationally harmful.
Yes.
Illegal sa state.
Yes. That's the example. Now, we proceed to what conduct are attributable to state. For this known example. Conduct of its own organs. Okay? Or meaning the department of the state. Conduct of a person, entity empowered by law of the state. Meaning he is authorized to do it. But he commits an unlawful act. That act is attributable to the state that he represents. Okay? What else? Conduct of a person or group that is in fact acting on its instruction or under the direction or of control of the state. Okay? Or a military is instructed to do this. That act is not the act of the military itself, but the act of the state. So, the state that causes the causes the damage of the military will be held liable. Okay? The conduct of an insurrectional movement which becomes the new government. Okay? What do you mean by insurrection? You fight against the existing government. Okay? To rebellion. But you become the new government. Okay? So that is, you will be held liable over its acts. And the last, or the sixth rather, is the conduct or movement of insurrectional or other which succeeds establishing new state. Conduct which the state acknowledges and adopts its own as its own. So they adopt the act as their own, then they may be held responsible. We call it is as attribution. Okay, so get one fourth.